Hello, welcome to the course of Introduction to Business Law. I am Syed Mohammad Riazul Haq. We are going to study a new topic related to the business law, and we will see how this business law is important for the organization as well. So today lecture will be also very much beneficial and informative for all you guys. Today we will talk about the contract of indemnity. So, first of all, what is the question? Where is the question arises here is what is the indemnity? Indemnity, we can say that it is also one kind of profit, we can say, also the sharing, also the part of the revenue, we can say like this. But in business point of view, it has a different definitions. And when we want to set the profits and in Urdu we say also the mafza, indemnity. And then we want to set a contract between the two parties. So we will see how it is performed and what are the other aspects of this. Excuse me. So if you look here in the second slide we have here, and I would like to maximize it. Okay, and this will work. So in today's contents we have here contract of indemnity, features of indemnity, and contract of guarantee, and types of guarantee, contract of bailment, and kinds of bailment. Also, in previous lecture we also talked about the guarantee of the warranty, but in today's lecture we will also have a look on the warranty, on the guarantee type, and we will see how it is according to the business law as well. So if you go to the context of indemnity, so first of all, we have to understand the meaning and definition of the indemnity as well. So meaning and definition of indemnity, according to the section 124, defines a contract of indemnity as a contract of indemnity is a contract whereby one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. So you will see here one thing is important, that here is a contract of indemnity is a contract, and here one party promises, one party says that I will save you from the damage, from the losses which is caused by me, then by him, like this. So I will save you. So here is the same phrase, a contract of indemnity is a contract whereby one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. So definition of indemnity under section 124 is restrictive, and then we have some features of indemnity as well. So here are some features of indemnity. Number one, we have it must possess all ingredients of a valid agreement, and we have understand and we have studied before what is the valid agreement. For example, the agreement should be valid. It is not according, it shouldn't be according, it shouldn't be against the law of the constitution of Pakistan, like against the law, business law of the Pakistan. You can say the ordinance of the Pakistan, factory ordinance of the Pakistan, like this, that there isn't be any kind of contract of the illegal goods and illegal services like or drugs type thing which is forbidden in this region. So wherever you go, whatever is the country you are living, so you have to study the law of that country if you are doing the business and making any kind of contract between you and other people or between two parties. So first of all, you should know what is forbidden according to the law of that particular country as, and then you will decide you should do this or sometime by conscious you know that it is illegal, but sometimes we should know, okay, what are the more things which is illegal according to the law. So number first thing, it must possess all ingredients of a valid agreement. Number two, it is a contingent agreement to make good the law. It is a contingent agreement. And number third, we have the loss must be caused by human conduct only. So if the loss caused by the climate, caused by the weather, caused by the nature, so it is not the responsibility of the promisor to pay the loss or to save the loss, because it is for all, like earthquake scenario, or some kind of accident which is not conducted by the human, there isn't any involvement of the human. So we will here will say that if there is no involvement of the human and the accident, the cause and the loss is due to the other things, unhuman things or climates or nature, so it is not according, it is then we can say then the promisor is not the responsible for that. So it is the loss must be caused by the human conduct only. And number four, we have the loss must have actually been suffered, because we have the loss will happen and what are the causes of the loss, and either it impacted or not impacted. The loss must have actually been suffered as well. So we have here also the contract of indemnity parties. Parties to contract of indemnity. So here we have indemnifier, number one, we say. Number two, indemnity holder. And for example, we have motor insurance and marine insurance. So here we have the example of the indemnifier and indemnity. The fire insurance, life insurance is not the contract of indemnity, because here is it is not human conducting. The fire sometimes happen like fire insurance, life insurance are not included in the contract of the indemnity because it happens, accidentally happens sometimes. So here is some privileges. And now we will see the rights of indemnity holders when sued. What is the rights of the indemnity holders? When it's sued, when the contract is going to invalid like this, when the contract is going to breach. So all damages, all cost, all sums, he can sue for all damages, all cost, all sums. And right, what are the rights of indemnify? The rights of indemnify here. The Contract Act is silent about the rights. Right, the Contract Act is silent because all the rights here the indemnity holder. So here is one important thing also. So we can say that now we will talk about the contract of guarantee. And we have discussed before about the warranties. Now we will talk about the contract of guarantee. The meaning and definition we have here, the contract of guarantee is defined by the Contract Act as a contract to perform the promising, a contract to perform the promise or discharge the liability of a third person in case of his default. A guarantee may be either oral or written. So here we have some point to put that the guarantee may be either oral, verbal, we can say, or written as well. But here the contract to perform the promising or discharge the liability of a third person in case of his default, it should be. And then essentials of contract of guarantee. What are the essentials of contract of guarantee? We have here existence of a principal debt, number one. Consideration for a contract of guarantee. What are the considerations decided between the parties? So consideration, and there should be no misrepresentation or concealment. There should be no misrepresentation. There should be a representation, fixed representation, but not the misrepresentations or concealment. And number four, we have here contract of guarantee must contain all the essential element of a valid contract that we have also some in the features of contract of indemnity. So here it is the same rule here apply for contract of guarantee. Okay? Of a person, if a company is giving you the guarantee, I have a guarantee. I take the guarantee of for this course for this act. So when you are formulating a contract of guarantee, so you have to consider this as well. The contract of guarantee must contain all the essential elements of valid contract. And number four, we have here the contract of guarantee is a complete and separate contract by itself. You cannot merge one into another. The contract of guarantee should be a completed and separated. And by nature, it is separate from the other contract. So parties to contract of guarantees, what we call to them? So surety, number one. Number two, the one party is surety. Number two is principal debtor, and number three is creditor. Who take the surety? Who is the principal debtor? And who is the creditor? And who take our surety? There are three parties involved in contract. Here we have the types of guarantee. Number one, we have the special guarantee. What is the special guarantee? A guarantee is a specific guarantee if it is intended to be applicable to a particular debt or thus comes to an end on its employment. When it is called the specific guarantee, when it is the intention to be applicable to a particular debt and thus comes to an end on its repayment, we can say. Then we can it is a special guarantee. Continuing guarantee number second, we have the kind a guarantee which extends to a series of transactions is called a continuing guarantee. Where there is a series of transactions, one, two, three, series of transactions. So we can say that it is a continuing guarantee. Example, we have fidelity guarantees. Similarly, we have here number two, overdraft. These are the examples for the continuing guarantee. They always come on. Well, now we talk about the rights of the creditors and the rights of the surety, and what is the against of the creditor and against the surety. So first of all, we'll see right of surety against the principal debtor. What is the right of surety against the principal debtor? Number one, rights of subrogation. Number two, rights to indemnity. Rights to indemnity and rights of subrogation again as against the principal debtor. And against the creditor, what is the right of surety? Right of securities it has, and right to claim set off. Similarly, against the co-sureties, if there are a number of two sureties. So when several co-sureties have given guarantees for the same debt with their maximum limits, they are liable to pay equally but subject to the limits they have fixed. And here we have discharge of surety. So what are the factors involved in discharge of surety? How can be the discharge the surety? Number one, we have revocation by notice, through notice. Number two, revocation by debt, if the any person is died there, any party can say. Discharge of surety by variance in terms of contract. And number four, we have discharge of surety by release or discharge of principal debtor. And discharge of surety when creditor compounds with gives time to or agrees not to insure principal debtor. And then creditors forbearance to sue does not discharge surety. Creditors forbearance to sue does not discharge surety. So here release of one co-surety does not discharge other. How can you discharge? If there is a release of one surety, you cannot discharge. So we have here very important point. The release of one co-surety does not discharge other, and discharge of surety by creditors act or omission impairing surety eventually remedy. And by the creditor losing his security, also discharge of the surety, and by concealment or misrepresentation, surety discharge by itself. Well, now we will talk about what is bailment. Today we have some small topics, so I am going a little fast. Perhaps you are watching that, I am going fast, but it is very easy topic. You have understand this. You should also read from the books and the website of these to understand this kind of concept and also the examples so that you get more information related to this. Bailment. The word bailment, you know very well. Always you listen this person. Bail ho gayi janab, inki bail ho gayi, come out from the jail. Like so, what is the bailment? So, Section 148 defines the bailment as what it defines. Section 148, remember it. The delivery of goods by one to another person for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. You have to understand, once again, I am reading for you. The delivery of goods by one to another person for some purpose upon a contract that they shall, when the purpose is accomplished, be returned to or otherwise disposed of according to the direction of the persons delivering them. The person delivering the goods is called the bailer. Okay, the person delivering the goods is called the bailer, and the person to whom goods are delivered is called the bailee. It's called the bailee. So we have two parties here, the bailer and the bailee. Like in the contract of performance, we have a promisor and promisee. Here, bailer and bailee. So, kinds of bailment. What are the kinds of bailment? Number one, on the basis of benefits. Let's talk about first, according to the basis of the benefits, what are the kinds of the bailment? Number one, we have bailment exclusive for bailer's benefit, bailment exclusive for bailee's benefit, and bailment for mutual benefit. For exclusive for bailer benefit and exclusive for bailiff's benefit and mutual benefits of bailment for mutual benefit. And we can also categorize these kinds of bailment according to the basis of willingness. So here we have voluntary bailment, involuntary bailment on the basis of rewards, gratuitous bailment, non-gratuitous bailment. So essential of pledge. When we talk about the pledge, so delivery of goods, it is very essential of pledge. Delivery of goods should be by way of security, and good must be movable. It is not talking about the land which cannot movable. The delivery of goods, the delivery of goods should be by way of security, and the goods must be movable. It is not for the goods that cannot be movable. So rights and duties of pony kya hota hai? So rights of retainer, right of particular lien, and rights of extraordinary expenses, and right in case of default. These are basically the kinds of the rights of the public. Very little we just go through on these topics, and of course you have to study and learn more about these things. So we little bit talk. We talked about the bailment, we talked about the guarantee, and we saw the types of guarantee. And similarly, we have discussed about contract of indemnity. So here, if I ask you some question like the contract of indemnity, so what are the parties here? You will see the indemnity file. If I ask you the question, or in the MCQ, they will ask you the parties of the bailment. So you will see that there are two parties. You can ask you as an MCQs as well. Like one is called the bailer, and second is called the bailee. It is similarly like the when we talked and discussed about the contract of the performance. So we saw that there were also two parties like the promisee and the promisers. So it is very easy. Just you have to go and find out the more details from your book and read and study and find out the case study. Do an assignment. It is also for your assignment to explain each and every point that I mentioned today in our lecture. So that's is a basic and fundamental kinds of contract of the indemnity and contract of guarantee and contract of bailment. Three aspects we discussed introductory as an introductory level as well. So, well, that's all for today. Take care. Allah Hafiz. Goodbye.